everyone. Welcome to the January docket of the Court of Criminal Appeals in Jackson. I will introduce the panel. To my left is Judge Matt Wilson from here in Jackson. To my right is Judge John Campbell from Memphis. I'm Ross Dyer, also from Memphis. Each side will have 20 minutes. Appellant, if you'd like to reserve any time, please notify us as you start so that the clerk can keep time. You can assume we have read the briefs, have not read the record, so use your time however you want as far as giving us factual background and information. With that, Madam Clerk, do we have any preliminary matters?
Yes, Your Honor. Attorney General John Bledsoe would like to make some introductions.
Mr. Bledsoe, how are you, sir?
I'm well. Good morning, Your Honor.
Good morning.
John Bledsoe from the Attorney General's office. I just wanted to take a moment at the beginning to introduce two of our attorneys in the Attorney General's office who will be presenting before this court for the first time today. Katie Neff is on the first case this morning. She is a graduate of Loyola University Law School in Los Angeles. She's from California. She comes to us after a brief stint as a prosecutor in the 32nd Judicial District. Before that, she was a prosecutor for a good while in Orange County, California. On our second case, Jacob Durst is Ms. Neff is in our Criminal Appeals Division. Mr. Durst is in our Strategic Litigation Unit. He is from Texas. He comes to us following a federal judicial clerkship in Texas. We're happy to have both of them in the office and before the court today to ably represent the interests of the state.
Thank you, Mr. Bledsoe. Welcome to both of you. We will look forward to hearing from you. We'll try our best to be nice to you on your first time. Thank you. Madam Clerk, if you'll call the first case, please.
Re Ann Blankenship.
Judge Dyer, I hope you'll extend that same.
I'm not going to, because I'm going to go ahead and start you off with a question before you even introduce yourself. I'll be nice with my question. How about that?
Yes, sir. If the court please, this is David. My name is David Camp, and may it please the court at this time, I represent Ann Blankenship Bonding Company. I would at this time request 5 minutes for rebuttal, if I may. This is a matter...
Seriously, Mr. Camp, I do have a question for you.
Yes, sir.
What's the remedy here?
The remedy?
Yeah.
The remedy is that you reverse the court's decision, that you basically reinstate her reputation from the perspective that she should not have been suspended under these circumstances, or you can remand it back for a hearing that should have been conducted in conformity with 4011-125B, which is what should have been done in this case and was not done. It's a matter of assuring that proper procedure has been followed in this case. And I've identified for the court as well in the brief that there is, in fact, jurisdiction for this court to hear it. It is not moot simply because it's already been decided.
And I get that. I'm not challenging that question.
Yes,
my point is, should we agree with you and say that the trial court, for whatever reason, did this wrong, whether it's notice, whether it's not sufficient evidence, whatever we find? She's already served the 45-day suspension. It's not like there's a record, so to speak, like in a criminal case where they're going to run a pre-sentence report later if she ever gets in trouble again. It's just there's not. How do we restore anything? What are we doing?
Well, the remedy, Judge, is assuring that the trial courts follow the proper procedure as it relates to the manner in which they conduct these hearings to assure there's uniformity across all of the districts, and that they make some determination based on what proof has to be presented and the manner in which it needs to be presented. And quite frankly, I can address the court on what I consider to be an answer to that question, where you would often say you begin at the beginning. What I would submit to the court is I can almost begin at the end. If you look at Judge Bradbury's decision, and in volume 1, page 42, but I think I've cited it as well in the brief, and I'll quote that paragraph. And this is the one that's probably and should be perhaps the most telling concern that the court should raise, our court should consider as being raised, is Judge Bradbury, in reviewing this and then having this hearing, made a statement and quoted it in his order. And he said the following: since first taking the bench in October of 2021, the court has heard multiple complaints from law enforcement and county officials about the conduct of Ann Blankenship in her capacity as a professional bondsman. It appears this conduct has occurred for several years without consequence. The actions of Ms. Blankenship cast shade on professional bondsmen and the entire judicial system. These unprofessional activities are not accepted in the 24th Judicial District. That's part of his decision. And the problem that this creates is now we're bringing into what should be a fairly straightforward procedure under 4011-125B that says you're to take into account a hearing, hear evidence, have witnesses come in, and then allow the party who's been aggrieved in this case, the party who's had the complaint filed against them, to be able to respond to that in a court setting.
So let me ask you this, though. So the notice, the complaint, clearly sets out that there's no signage, permanent place of business is one of the claims, correct?
That's correct.
Okay. And your client testified concerning that issue.
Yes, sir.
Okay. Now, what you're talking about, I'll call it the hearsay information the trial court talked about and relied on, it's not in the complaint, it's not in the notice, so to speak. He just starts talking about it.
Yes, sir.
So let's say that he's wrong on that. He's wrong on that aspect. But let's say he's right on the other.
Okay.
Are you entitled to relief then? Just because he was wrong on one thing, but he was right on another?
Well, I think you have to take it in the totality, and that's correct. But if we're going to address about the signage issue, that would be covered under, I think, 40-11-126, and I think it's 9, or what would be, 9, regarding the professional business, permanent business with signage. That's the section we're referring to here. I can't concede that the judge was right in that respect.
I know you can't.
Well, and I can't because under the proof that was presented, and what's probably most important is, and this is probably troublesome as well, is that the complaining party never showed up. They filed this complaint. It went to the judge. You had an affidavit that was submitted by nephew, former employee that was disgruntled anyway. This was the basis of what started all this. So when the judge got into the questioning about the signage issue and the permanent business location, she has one, and she has signage. Now, what she has is she's got 2 addresses, but they're both permanent, and she operated out of both of those. And she identified that and said that. Now, her card identified one address, but she also operated out of another, which was her mother's home. So she did have signage, and she did have a permanent.
But she didn't have signage at this one particular location, where her business card indicated was her office.
That is correct.
Okay.
That is correct.
And she admits that.
She does.
That was uncontested. I guess you shouldn't say uncontested, but she does admit that in fact, is the case.
Correct. 857 is where she had her card, and I think it was 896 or 897. That's the other address on Crawford Road. That's where she actually had her signage set up. She kept her business papers at the one address, but she actually worked out of the other. But to operate as a bondsman, you're not operating out of those businesses. You're going to the jail and writing bonds. You're meeting the family at the jail and writing these bonds.
Well, but there's a reason that the statute requires you to have signage.
It is.
It's not just thrown in language, because the statute requires you to have signage so that the public can know where to find you, correct?
Partially, but not totally.
Well, I mean, here's where my business is, here's where you can find me, my sign's right here. And if I'm not mistaken, and correct me if I'm wrong, but the signage business was behind a fence.
There was a gate that was as far as, no, the signage was not behind the.
No, the signage is on the porch of the house that's behind the fence.
The signage was not behind the fence. The signage was in an address that was at the, I believe, the 896 address. 857, which is on the card, was behind the gate, but the signage wasn't behind the gate.
Okay, so either way, if that's the case, and the card's telling me to go to this other location that's behind a gate, I mean.
Well, the purpose of 40-11-126-9 is nothing to do with this public issue I think the court stressed on, and I think that was addressed in the brief filed by the state. There was a problem before 9 was enacted, because the problem was you would have bonding company come in from out of state that would set up shop in motel rooms, and literally they'd have sureties out of state. And so when a person who's let out on bonds.
Is that in the record?
Well, no, so this is just part of the basis of what the argument is regarding to responding to what the basis of that support is. I'm just giving the court a little bit of
I know,
historical
but what my
aspect
point
of
is,
this.
I mean, if all this information is not in the record as to why the statute's drafted the way it's drafted, then all we're doing is looking at the statute, and the statute says a permanent place of business.
I
It doesn't say
concede that.
multiple permanent places of business. It doesn't say, it just says a permanent place of business with signage and a phone number.
Well, I concede that to the court. It's not in the record as to the purpose of 9 on either side. I mean, the state in its brief identified some reasoning they thought was some sort of complex financial transactions, which is beyond me. None of that was argued before Judge Bradbury, because I can assure you in Decaturville, there are no complex financial transactions involving bonding. It's let my nephew out because he's in jail and he needs some help. So the key to it is that I don't know where all that came from, and I think my response here orally was to say that that's not really the purpose of it, but I can concede the point. It's not in the record on either side. The problem is it still takes us back to the same point. What's in the record? And what's in the record is unrefuted testimony under oath by Ann Blankenship saying she had a permanent residence, or she had a permanent business address, which she did. She had signage, which she did. I think the question is, can you have more than one business address? And the answer is, the statute doesn't say you can't. The statute says you just have a permanent business office, and she'd had one. And so that's basically it. That was her defense. That's what she set out in her testimony. And
So
again,
do you
nobody
read-
was there to counter
Do
that.
you read the statute to be as broad as, you have to have a permanent place of business, you can have signage over here, and you can have a phone number that goes somewhere else, and you meet the statute?
Well, what I read under 9, and I'll read it directly, quote 4011-126-9, engage in business of a professional bondsman or surety without maintaining a permanent business office, business telephone, and appropriate signage indicating that the office is a professional bail bonds business. That's exactly what it says. She operated her bail bond business out of 2 different locations. She had signage in one of those locations, and the location where people could find her through her phone number was at that location. And these are just right next to her. They're down the street from each other on Crawford Road. It's not like they're in different areas of the county. And she actually did her bonding work at the jail, which is where any of these bondsmen go. So I'm sure even if you get into the aspect of it, at best, technical violation, the spirit of what this is about was certainly not violated by her and certainly not justifiable of a 45-day suspension. And that's the biggest issue, I think, in context with this well, is why was that suspension as heavy as it was, and upon what was the court relying? Now, I also brought out to the court the issue regarding this video, and I'm not trying to get off track on the question about the signage. I'll answer as many questions as the court may have. But the video issue was another aspect of it, which also goes to the heart of what's considered to be probably the difficulties in this hearing and the way it was conducted. You had 3 people at this hearing. You had the judge, you had Ms. Blankenship, and you had her lawyer. You supposedly had a complainant, and I guess what I bring up as well, too, and address this, too, is the district attorney's office didn't even get involved in this.
The
even
statute
though they
doesn't
were
require
asked
the district attorney's office to be involved.
It doesn't, but they were notified of it and identified that they could be there if they chose to, and they chose not to come. That was basically their decision to do so.
That's not a denial of due process to your client that the DA's office chose not to come. They chose not to come. They're not required to be there.
The problem that I'm having is they're here now. And I think the question that I have to ask the court is if we're serious about the fact that there's some effort on their part to enforce these bonding restrictions, then why weren't they there to argue these issues that are being argued today before the court?
They didn't file the complaint.
Well, the complaint was filed by a private citizen who also didn't pursue it. So Ms. Blankenship showed up, she answered the charges, she truthfully responded to all the questions asked for, and she provided explanations for any of the allegations that were raised. And she raised those very clearly. Now, one of the problems that we had in this hearing is Judge Bradbury took into account things that were not in the court. The video was a prime example. He goes and watches some video, the court goes and watches a video ex parte, and then brings in what the courts were, viewed when he saw the video, but then turns around and uses that as a basis to support his allegations or his findings in his order, that she violated some contact issue regarding some potential individual that was wanting out on bond. How do you respond to that?
Well, she did respond to it, though.
Well, she did. She said that she didn't do it, and there was no indication. How could she respond to a video she wasn't seeing? So the problem we've got is that we could very well send this back down to Judge Bradbury. We might very well get the same result. I don't know. But at least if the court sends it back with instructions to follow the requirements under 4011-125B, we'll know that it was fairly done and that she had a fair opportunity in a hearing before an impartial judge. And the concern is the partiality or impartiality of the court in this case because of the statements that were made by the court during the course and conduct of the hearing, as well as in the findings that the court had.
Do you think that, do you really think that the judge saying, since I've taken the bench, I've heard negative things about you, reflects on his impartiality, or is it just improper for him to consider? Those are two different things.
I don't know why it was said, is the problem I'm having. Because if the court's going to sit and determine that it's going to enforce its ministerial authority and use its inherent authority to make a determination on someone's livelihood, if the court is bringing into the court system the judicial hearing that's mandated under 4011-125B and makes those kind of comments and statements, how does Ms. Blankenship look at that? How does she know that she's getting a fair hearing?
Trial judges, this court, whomever, can make improper statements, erroneous statements, but not necessarily being a reflection on how they feel about your client. They just get it wrong.
Well, I read the paragraph literally that I read to the court at the beginning of this argument, and that doesn't appear to be anything but impartial, or partial, if you would, excuse me. Partial is the right term. Because under the circumstances, it's clear the court went into this having reviewed a video ex parte, and then having made this decision and made these statements and these comments, plus you've got this rift between her and her nephew, which obviously is well known about in the community because it's a small community. And so these are all external factors being brought into this. And so if you're going to have a hearing on something like this, you need to be removed from all of it, just like any court should be removed, and making a decision based solely on what evidence comes before the court. And that's why 4011-125B specifically, and I've laid that out in my reply brief for the court, it specifically mandates that the parties come before the court, the witnesses are called, and evidence is provided. That's a strict, standard adversarial process that's to be followed.
So being strict with what you just said, the parties came before the court, your client came before the court.
Yes, that's right.
She's testified, and she was asked about certain questions, and she refuted or admitted or however she did. What else is required?
Well, one, if the court is bringing in ex parte evidence of video and questioning her about a video she hasn't seen, then she needs to be able to see the video.
Okay, throw the video out.
All right? Then that's one of the aspects of what
I
the court
understand,
relied on.
but the permanent place of business and the signage question,
Yes, sir.
who else needs to be there for that conversation other than her and the judge? And the pictures that were introduced.
The pictures were introduced by her showing the signage was there.
So who
That's
else needs to
correct.
be there?
I don't know that anybody else could be there on that aspect of it. I'm not sure to what extent the court relied on just that part of it in making that decision.
I understand that.
So
And
that's the problem.
And that kind of comes to my other question. You know, this is not like a sentencing issue, let's say, where the trial judge relies on 3 or 4 enhancement factors and we say, hey, 2 of those are wrong, but at the end of the day, you got 1 or 2 of them right, and therefore the sentence is fine. Is it, or is it, hey, if you get one thing wrong, the whole thing's bad? Because if we find that the signage and the permanent place of business is correct, which you just said, no one needed to be there but her and the judge, and we find that he was correct on that, but he was wrong on everything else, can we still affirm it?
I don't believe you can, because the problem is I don't know to what extent the court relied on and the other factors you've just removed
But
in
it's-
making its decision on what it passed as far as the punishment.
But it's a discretionary call on his part,
Yes, sir.
and, you know, yes, without him telling us, hey, this gets you 10 days, this gets you 3 days, this gets you however many days, we don't know, but we do know that she has a violation, and he felt that her violation or violations was worth 45 days. How do we say he's wrong on that if he's at least right on one of the issues?
I was incorrect on one statement I just said previously, right before this, which is it's a de novo review by this court.
Yeah,
So the
I
court-
understand.
That's what I meant from the review. When the court said discretionary, I didn't want to confuse that with abuse of discretion.
He has discretion,
He
ours
has-
is de novo.
He does have discretion, but the reality of it is, given the nature of what was put in the order, I would submit to the court that under those circumstances, I don't know how this court separate those out. If the court finds that the violation of the video was improperly considered by the court, if the court finds that these ex parte comments made by who knows who over all these years making comments and statements about Ms. Blankenship should not have been considered by the court, I don't see how this court, and I mean this in all due respect, can go in and say, oh, but okay, you're okay on this part, so we're going to find that your ruling's all right there on the 45 days because of signage. But again, I would submit to the court too, you can look at the language under 4011-126-9 and make that determination for itself. The court can make this call. Is she in fact in violation of that anyway? Because she did have a permanent place of business and she did have signage. And so I think that's ultimately what the court has to decide is did that in fact comply? And there are photographs, and the court's absolutely correct, and they're in volume 1 and 34 through 38 are the photographs in the record that were introduced by Ms. Blankenship. And Judge, I apologize, the clock's not on here, and I'm not sure where I am on time, so I'm not sure if I still have time or if I've gone over. Okay, I'm sorry. I'll defer. I usually get, and I just realized that
We'll still
wasn't on.
give you your rebuttal
I
time.
apologize. Thank you, Judge.
Thank you.
Good morning, Your Honors, and may it please the Court. Katie Neff on behalf of the state. It is well settled that trial courts have inherent authority to regulate the bonding companies that write bonds within their judicial districts. In light of that authority, the trial court here imposed a 45-day suspension after finding that Ms. Blankenship engaged in multiple counts of professional misconduct. Because the record supports the trial court suspension, this court should affirm. So I want to start by talking about Section 4011-126, which lays out the statutory definition of professional misconduct. Turning first to Section 9, counsel already read it, but it prohibits professional bonding companies from engaging in business without maintaining a permanent business office, business telephone, and appropriate signage indicating that the office is a professional bail bond business.
Do all those have to be at the same location?
Yes, and let me tell you why that is. Because let me start by saying, it has to be at the same location. Your Honors may be aware that there are bonding companies that operate in multiple counties. It cannot be the case that having a location in Memphis and having signage in Memphis permits you to have no signage in your Nashville office. It doesn't make sense, and it doesn't make sense within the plain reading of the statute. But here, Ms. Blankenship did more than just have two offices and failed to put up signage at both. It is clear that her address at 857 Crawford School Road was the primary place of business. This is the address that's reflected on her business card. It is the address that's reflected on her court documents. It's the address that's reflected on, by her own words, all her paperwork. And yet, if a member of the public or a bonding client were to go to that location, they would not see any sign indicating that that property is a location that is a professional bail bonding business.
So you would also take that when she says all her paperwork, that means the paperwork that's filed with the clerk's office to show who's on the bond, correct?
I would think it would include that.
And so the clerk's office, therefore the judge and whomever would need to know where to go find that bonding officer.
Exactly. And so because she failed to keep appropriate signage at what I believe is the primary place of business, but regardless is a place that she says that she operates a business, if a member of the public were to go there, they would not be able to see any signage indicating that it's a bail bonding business. And for that reason, she runs afoul of Section 9. Also turning to subsection 6, prohibits bonding companies from soliciting business directly or indirectly by active or passive means or engaging in any other conduct which may be reasonably construed as intended for the purpose of solicitation of business in places where prisoners are confined or in the immediate areas around there. And the trial court here found that Ms. Blankenship solicited business from a prisoner who was just released after writing a bond with a competitor bonding company. And she did so in the parking lot of a jail.
Did the defendant, or the bonding company, have, did she have the opportunity to review that video?
She did, Your Honor. If you look to Volume 2, page 34, the trial court says expressly, I provided a video, I've reviewed it, I provided a video to you. Will you explain what is happening in that video? And her response under oath was to begin to talk about the circumstance that underlied that video, that was that interaction.
And is that video in the record, though?
It is not in the record, Your Honor, and I think that's why it is difficult for appellant to come here and ask for this court to review and undo what the trial court did without even ensuring that this court has all of the evidence the trial court relied on. Ms. Blankenship was provided the video, the trial court reviewed the video, the trial court gave Ms. Blankenship an opportunity to explain the video. And then, even though she had the ability at the trial court level to make it part of the record, and she had the duty on the appellate level to make it part of the record, she failed to do so. Even after the state raised this as an issue, she has done nothing to make that video part of this record and to give that video for this court's review. She has waived review of that issue, and this court should defer to the trial court's factual finding on this point. Because the trial court properly found that Ms. Blankenship engaged in multiple instances of professional misconduct, this court should affirm it.
So well, how do you respond, though, to the trial court, which it clearly is a finding, where he relies on hearsay information that the bonding agent didn't have any notice of when she showed up for that hearing?
Well, I would say first that, Your Honors, there were multiple types of misconduct that Ms. Blankenship was given proper notice of and that they had a full and fair hearing on, and that would be enough for this court's de novo review to find that the trial court's order would stand and to affirm the trial court's order. But I would also push back a little bit on the characterization that this was a finding. I think of it more as an admonition or a warning, which goes back to what I said at the beginning of this hearing, which is that trial courts have inherent authority to regulate the bonding companies, and that doesn't begin and end with punishment. It doesn't start with revocations or with suspensions. It has to go beyond that. It has to be some element of warning and educating and admonition. And if you look at the actual language of that part of the order, that's clearly what it is. The trial court says, look, I've been hearing these things for a while. They've gone unaddressed thus far. This will not be tolerated in the 24th Judicial District. And the reason I can say I feel confident that it is not a part of the findings is that the trial court actually enumerated its factual findings. It said, I find that she's engaged in professional misconduct for these specific reasons. That comment, that admonition is a standalone. It is not enumerated. It's not part of that finding. And I don't believe that the trial court, just plain reading of the order, I don't believe that the trial court intended to make that part of its finding of professional misconduct.
But he made his findings like against the backdrop of, hey, I've been hearing this for a while and you've been a problem since I took the bench in October of 21. I mean, that's really Mr. Camp's argument, is it not, as to the impartiality aspect of it?
Well, I understand the court's concern that the court might have been influenced somehow by it, but importantly, that wasn't the basis of its finding of its suspension order. The court laid out its orders, and even if this court did find that it was a finding, you still are able to affirm the trial court's order because there were specific enumerated findings that she did have plenty of notice for, that she did have hearings for, that support the trial court suspension.
But to Mr. Camp's point, how do we know how the trial court got to 45 days? And the trial court could have said, hey, permanent signage or permanent place of business signage issue, okay, that's a finding. Solicitation is a finding. But to Judge Wilson's question, the backdrop behind all this is you've been a problem since the beginning, and therefore I'm giving you 45 days. How do we we don't know. He may have found those two and said, in his mind, that's 45 days, but he also could have said those two, but in light of everything I've been hearing since I took the bench, you need to be suspended 45 days. We don't, there's no way for us to tell that from the record, is there?
Not specifically, other than that the trial court made it suspended based on the finding of professional misconduct. It cited specifically Section 125, which permits trial courts to suspend or revoke based on findings of professional misconduct, and then it cites specifically Section 126. The trial court's order lists out what it found violated that section and then suspended. So I don't think that the trial courts are, if this court wanted to, you could require trial courts to say, I give 5 days for this, I give 2 days for that. But I think under de novo review, you would be permitted to look at this, look at what you were persuaded by, and determine whether or not 45 days is appropriate.
So let me ask you this. If we were to find that or determine that the history issue with this individual was a finding by the trial court, would you concede that she didn't have notice of that claim?
You put me in a difficult position, Your Honor. I don't believe that it was a finding, and I would need to have additional briefing before I concede something like that. I think you've worked in my office. There's more that's needed.
Well,
but
I mean,
because
it's pretty easy. It's not in the complaint, and the complaint is the notice, correct? So she didn't have notice of that the trial judge was going to rely on outside information outside of that.
And here's why I would need to look at that more. If I recall just off the top of my head, I think there was some discussion about the long history that she's had with Mr. Blankenship and some other issues. So I would need to look at that more clearly before I conceded something like that. But regardless, even if this court did find that that was part of the factual findings, this court can still come to an affirmation because the factual findings that were enumerated, she did have notice of them, she had a full hearing on them, and they are supported by the record. And so for that reason, I would ask this court to affirm.
Thank you.
Thank you, Your Honors.
Mr. Camp, your rebuttal.
Yes, sir, Judge. In a light, I think having gone over, I'll be brief. I think I've covered most through my initial argument, but I do want to touch on a couple of points that have been brought out here. I have already recited directly to the court, I'll not continue to read it, on page 42 of volume 1, where the court made that comment about those issues regarding taking into account that. It's interesting the argument the state makes that it's not part of the finding when in fact it's in the court's order. But it's perhaps more than just a finding, it's an insight into the thinking of the court and to the issues that the court is bringing into the courtroom with it when supposedly conducting what would otherwise be an impartial hearing.
To the state's comment that this was an admonition, a warning, however you want to look at it, how is this, if that's true, I mean, how is that any different than a judge when sentencing a defendant says things like, you know, you need to get your life, you've been here enough, you need to get things straight, I don't want to see you in here again. I mean, we don't say that's improper comments during a sentencing hearing.
Well, the problem is that it's not as if the court is admonishing Ms. Blankenship because her signage is out of place.
No, but he's saying, look, I found these two things, and for that I'm under the state's theory, I found these two things, I'm suspending you 45 days. And look, you've got a history, and now I've just made a finding, and I don't need to see you in here again. You need to get your business together. I mean, can that not be a reasonable interpretation of the court's order?
It still takes you outside the scope of 4011-125B, which says that the court has to take into account the evidence presented to the court in making a ruling. This statement from the court is, the court has heard multiple complaints from law enforcement and county officials. That triggers the notice provision and says, if you've got those complaints and those are part of what you're going to make as a finding, that there's unprofessional conduct, what are the complaints? Who are you hearing them from?
Well, that's what, I understand your position. My question is, the state's position is, he made two findings. That was not, he didn't make three, just to be simplistic about it. He made two findings. He made the signage finding, or permanent business finding, and he made the solicitation finding. He made those two findings. He then warned your client, hey, you've got a reputation, and you need to be careful going forward. That's a very simplistic way of stating what I hear the state's argument is.
And I understand that's the state position. Then what we need to do is go ahead and just throw out 4011-125B and just say we can just have a free-for-all in a courtroom when you come in and start determining whether or not somebody can write bonds in a district. Because now you bring in all this extraneous information and extraneous proof that's not even proof. Why do we have 4011-125B if that's the case? I would submit to the court that I think under the circumstances that is far-reaching to say that the court would write something to that nature. And I would even go as far as to say even beyond that, the court even went in and put in some kind of a policing effort where Ms. Blankenship could not be in the jail at the same time as her nephew, Herbie Blankenship. So now we're way beyond even that scope of it. Herbie Blankenship submits some kind of affidavit but doesn't show up in order to support that affidavit at the hearing, and yet now somehow that gets brought into it as well. I think the problem is very clear is that it went way beyond the scope of what 4011-125B is about. And under the circumstances, that's where the error occurred in this case. Procedurally, again, the remedy is a new hearing to be conducted properly, not one to be conducted in a way that you sort of combine what I consider to be Jerry Springer and Judge Judy. You just bring in all this extraneous information as sort of a turn loose on, let's just see what else we can bring out here and create a situation where she has no ability to defend herself on something that's her livelihood.
Why was the video not introduced?
I have no idea. Judge Bradbury had reviewed it. He basically said, this is what I saw. He apparently had it. I have no idea. That does raise the question, why wasn't it introduced? I mean, obviously.
Why didn't y'all introduce it?
Well, Judge, I'll be frank with the court. I wasn't there. Mr. Leonard was the one trying the case. He says he supplied it. There's no comment or response made back to it. I don't know where the video is. I can't find it. I will tell this. I've asked my client about it. My client doesn't know anything about where it is. So I don't want to get too far afield from it. But we know Judge Bradbury had it. So to me, if the circumstances are that it's going to be considered by the court in making a determination to suspend someone's ability to write bonds, the only one I could think of could have brought him was Judge Bradbury, because he obviously had it. So the court raises a good question. And for the perspective of even the appeal, I don't know I have no idea where this video is. Quite honestly, I have no clue, and my client doesn't either. So I think that's the problem that creates itself too when it's introduced in that way.
Mr. Camp, I guess finishing where Judge Dyer started,
Yes, sir.
did Mr. Leonard seek a stay or any suspension of the 45 days before it came into effect?
He did not, Judge, at all. I think under the circumstances, it was just handed down. At that point, he discontinued representation. I think he was hired strictly for that purpose. He never filed a motion to stay in anticipation of the appeal. And by the time I think we got involved in it, she'd already almost completed the full 45 days. The key is, could she have the right to still appeal it? And I think the court recognizes, and I put that in the brief, that she does. And I understand it's already been served, but we're hopeful that won't be prejudicial as to her in regards to whether or not this was properly handled. Thank you.
Thank you. Call the next case, please.
State of Tennessee versus Jeffrey Lane Jr.